Sir, I'll start the webinar, sir, so that
Yeah,
people
please go
will
ahead.
join. Yeah.
Yeah, yeah. Hello, Pawan.
Good evening, everyone. I hope I'm audible. Please confirm yes or no within your chat box. Hi, Mr. Somit. Yeah, the webinar will be started in few minutes. Thank you for mentioning. Please confirm with yes or no in chat box if I'm audible. Thank you all for joining this webinar. We'll be begin the webinar shortly. While we are waiting to start the webinar, I'd like to know if majority of our audience are from accounts background or any finance background. Please type your background or your qualification if you want to share something in chat box. Thank you, Mr. Naveen. Naveen is from finance background. Yes, we can see so many people are from finance and tax background. Thank you all for joining the webinar. While we all know today's topic is, I would like to know what exactly audience are expecting from this webinar. Would like to see some responses, or if you have any expectations and if you want to know more regarding this topic other than the agenda, you can type in the chat box so that we can cover the major part of your expectations in the webinar. Okay, GST litigation, we will cover that, Soumyajit. If you have any other expectations or any other topics to be covered related to GST litigation, you can type in the chat box, guys. We'll be starting the webinar in another 2 minutes. Since most of the other attendees also joining our webinar, we are giving heads up of 5 minutes so that we can start our webinar. Understanding GST litigations in brief and how implications are framed. Yes, Ganesh, we will be covering that. GST litigations, yes. I can also see so many repeated people who are joining our webinars from long back. Thank you all. I can see Soumyajit, I can see Arvind. You can see Krishna also. Thank you guys for joining our webinars. Manas asking AI on GST. I think I need to contact that. Thank you, Nageshwar, for your review. We'll be conducting these kind of sessions every week, every month. Uh, if you have any suggestions, we'd like to take on topic suggestions, you can mail at pawan.sahu@websol.com so that for our next upcoming webinars, we'll be preferring those specific webinar topics. You can reply to one of my emails as well, so that based on majority of the topics, we will be taking the same webinar for the next months. We'll be having a dedicated Q&A session as well at the end of the webinar. Keep your questions ready, guys. Or else you can type in the Q&A box. Okay, good evening, everyone. My name is Pawan Kumar Sahu. I handle product marketing at Websol. I'll be your moderator for the day. Before we head into webinar, I would like to give you a small introduction of my company that I represent from. I'll try to keep it short. Websol was part of Wipro back in the days. We were the printer manufacturing division of Wipro, and we are specialized in dot matrix printer category. Over the years, the company decided to step out of Wipro and form a separate entity in the name of Web Solutions. Our signature offering, Managed Print Services, was carried over 2 decades, and with evolving needs and changing market trends, we decided to bring digital workplace solutions to our portfolio. So we expanded our product and service portfolio to cater to mass markets. Over the years, we also collaborated with market giants like Ricoh and Fujifilm. I like to highlight few of our milestones in our journey that we underwent a complete brand transformation by the name of Websol. Let us move to the next slide where we talk about quick company highlights. We are in this industry for almost 20 plus years, and we have almost 500 plus enterprise customers. We are present in 2000 plus service locations in overall India. We in fact awarded as best DMS solution of the year and number one MBS company in continuous 2017 to 2019. You can see some of our trusted clients like Herbalife, JL Morrison, HDFC, Kotak, etc. Going to our services, FluidWorks is our intelligent workplace suite catering to wide range of interdepartmental functions. We have gamut of offerings like Fluid Print, Fluid Pro, Fluid Map, Fluid Tax, etc. in our portfolio. Moving on to Fluid Print, our print manufacturing infrastructure solutions according to your custom requirements. We offer both CapEx and OpEx models, and we charge customer pay-per-click basis. Fluid Trail is a process automation solution, which also offers document management hosted by Microsoft Cloud. We also offer managed GST solution for filing, GST reconciliation, e-invoicing, e-way bill, etc. Since most of the audience are from finance background, I would like to quickly launch a poll for you. The poll is on the screen. We have one of the solution called FlowTax, which is an automation solution for GST filing, reconciliation, e-invoicing, e-way bill. If you are interested in a free demo that we are conducting, which we will be explaining about all the automation in FlowTax, all the automation related to GST. Someone asked about AI also. We have some AI automation features, not exactly AI, but we have automation features. If you want to know more about our platform, you can click on yes in the poll box so that my team will reach you for giving you a free demo. Flotex is a platform, it's a GST management platform for all your GST needs like GST filing, reconciliation, e-invoicing, e-way bill, IMS, tax automations, etc. Recently, we have added IMS features as well. So if you are interested to know more about Flotex, our platform, and the automation of GST, you can click on yes so that my team will contact you for the demo. I'll be closing the poll in another 10 seconds, guys. Thank you all. Going on, I would like to introduce our speaker of the day, Mr. Akella Prakasa Rao, sir. Mr. Akella is an independent indirect tax advocate. He graduated in 1989 from BITS Pilani in electrical and electronics engineering. He is also a gold medal holder who completed LLB from Andhra University in the year 2001. And he has more than 7 years of experience in field of indirect taxes with an exposure in government, consultancy, and industries like auto and pharma. It's an absolute pleasure to have you as sir. I'm sure audience also looking forward to directly hear it from you.
Thank you, Paul. Thanks for the audience that you have joined in good numbers today. Maybe the topic at the middle of the last month of the financial year is interesting to you. So it is really surprising to see that people are interested in litigation, that there are many litigations happening around, and hence that we should be aware of what is the procedures that are followed in GST in order to fight our litigation, and what is the role of the tribunals. We are hearing so much about the tribunals, but we have not yet seen what the tribunal is. So how to go about it? So the agenda for this webinar is going to be what is litigation under the GST, what are the relevant provisions, and what is the hierarchy of the adjudication process, what is the role of GST tribunals, and what is the issue around it, why we are not able to see GST tribunals functioning, and what is the way forward and the Q&A. So I expect that most of you will have questions, and you please use the Q&A box to put your questions so that I will be able to take it up one after the other at the end of the presentation. So I will be rushing through the presentation. If any particular topic is required to be discussed in detail, you can ask for it so that I will be doing it. Otherwise, these slides will be shared with you. Hence, I don't want to spend too much of a time on it. So next slide, please, Power. So what is litigation under the GST? GST litigation refers to the disputes and conflicts arising out of an issue. In general, litigation refers to the dispute or the conflict arising out of an issue. But under GST, what can be the areas of litigation? It can be for rate of tax, it can be for classification, it can be for valuation, it can be for interpretation of a statutory provision, applicability of a notification, improper application of a legal provision or violation of the law and its procedures, delay in complying with the statutory provisions, and filing of the returns. So all these aspects can lead to a litigation. So a non-compliance or non-compliance with the law or non-compliance with the procedure, or misinterpretation, or with an intention to defraud the government if you are doing anything, all these things can lead to a litigation. So because of your genuine doubt also, there can be a litigation. Because of your misinterpretation, there can be a litigation. So it can be from many angles. So we should be aware of that where exactly we are by taking a particular position in this. Next slide, please. So what are the relevant provisions? If you just go through these sections which are going to be important, see, refund is not given. There is a scope for litigation only if the refund is not given or it is denied. So if it is denied, then it will be denied based on certain grounds, that denial of your ITC. So there can be many. It is a combination of these things. Since I did not mention separately, but yes, lot of litigation only on the refunds. You can say that every topic is subject to litigation only. And I'm not specifically mentioning that this topic is only for the litigation and this is litigation free. Nothing is litigation free. So what are the relevant provisions under the GST Act? If you see that these sections are going to be relevant. Section 61, which deals with the scrutiny of returns. 65, notice for conducting audit by the tax authorities. 66, a special audit by the chartered or cost auditor appointed by the tax authorities. 67, inspection, search and seizure. 70, summons. 73, determination of tax in non-fraud cases. 74, determination of tax in fraud cases. 76, tax collected but not paid to the government. 78, recovery proceedings. 107 is appeal with appellate authorities. 108 is a revisionary power. 112 is appeal with tribunal. 117 is appeal with High Court. 118 is appeal with Supreme Court. These are the relevant sections which are there, which are directly or indirectly leading to litigation and the other issues. Uh, there it seems to be some echo, but I'm not seeing anything over here, sir. Please bear with me. Next slide, please. So is there any poll question, Pawan, at this point of time?
No, sir, we'll do it later.
Yeah. Okay. So what is the hierarchy of the adjudicating authorities? If you see that what is going to be the appellate authorities, the original assessing authority will be either AC or DC or JC or ADC or the commissioner of CGST or SGST. So you may be falling in the jurisdiction of an SGST authority or the CGST authority. Once you are there, then depending on the amount involved in the notice or in the demand, then it can be decided by the ACDC or it will be decided either by the JC or ADC, or sometimes the matter may be at the level of the commissioner. So this is ACDC, JC, ADC or commissioner is depending on the financial powers of adjudication. If your matter is below 10 lakhs, it is going to be ACDC, JC and DC up to 50 lakhs and above 50 lakhs without any kind of a limit is a commissioner. But when the matter is involving suppression and section 74 is invoked, then commissioner comes into the picture. So depending on those criteria, the original authority is going to be decided. But once the order is passed by the original authority, then what is the appellate mechanism? So the first appellate happens to be JC in the case if the order is coming from an ACDC. If the assistant or deputy commissioner passes an order, then it is appealable with either joint or additional commissioner. But once the order is passed either by the joint commissioner or additional commissioner, it can be appealed only with the commissioner. So that is the reason I wrote the first appellate authority can be a JC or an ADC or the commissioner, depending on that who passed the original order. Sometimes it so happens if the original order has been passed by the commission itself, then it happens to be the first appellate authority happens to be the GST tribunal only, because against the commissioner's orders, the first appeal has to be filed with the GST tribunals only. The second appellate authority happens to be the ADC or the commissioner appeals in the CGST or the GST tribunal. So depending on that, it goes to that. Then there are some matters which can go to the High Court. There are some matters which cannot go to the High Court. They will be directly appealed with the Supreme Court, like the classification issues. Classification issues will not be decided by the High Court. It has to be directly decided by the Supreme Court. But otherwise, all other matters that the hierarchy is going to be from the tribunal, it is going to the High Court and then to the Supreme Court. This is how the adjudication structure is there under the GST. Next slide, please. Yeah, so here comes the role of the tribunals. So what exactly the tribunal's role is going to be in the process of litigation? See, for example, that you were issued a show cause notice and then you have filed your reply and then you have attended the personal hearing and the original adjudicating authority has decided the matter against you. Then the recourse for you will be to make the pre-deposit, because now by making a pre-deposit, the stay is consequential. So you need not apply for the stay separately, but you have to make the pre-deposit. And once you have made the pre-deposit and filed your appeal, the stay is automatically applies, and then the matter has to be heard by the appellate authority. But once the appellate authority has also heard the matter and then decided the matter against you, then you are approaching the tribunal. What requires to be done in case the second level of pre-deposit has not happened, then that portion also that you have to make the pre-deposit and then file your appeal. Then at the time of hearing, that either you or your counsel has to present the matter before the tribunal and the tribunal will decide. But in the past, what is our experience in this tribunal in the central excise, service tax and the customs, that there is a tribunal called Customs, Excise and Service Tax Appellate Tribunal. It is called SESTAT. So this SESTAT was there for the central taxes, but state VAT tribunals also used to be there. So the state VAT tribunals used to decide on the VAT as well as the CST matters. But once the VAT has been subsumed under the GST law, only the CST matters remain, for which the tribunal used to function. But very recently, the government has said the existing CST disputes are going to be dealt by the GST tribunals, and all the C form issues and other things are to be decided in a time bound manner. That's how the VAT tribunals have completely taken out of the scheme. Now the GST tribunal has to be constituted. But what is exactly the tribunal between the quasi-judicial authorities and the judicial authorities? Because High Court and Supreme Court are judicial authorities. So all the departmental officers are the quasi-judicial authorities. So what is the difference between these two? Is the quasi-judicial authorities are the same authorities who are going to go through your records, find out the problems in it, are the violation of the law, or the leakage of revenue, and on that they only make the demand and they only decide the matter. But whereas judicial authorities, the dispute will arise somewhere else. They are independent people. So the matter will be heard by them and they will interpret the law and then they will decide the matter. So this is a very important difference between a quasi-judicial and a judicial authority, because the quasi-judicial authority will also be the authority who is making the demand, and on his demand, he only will be making the final decision whether the demand sustains or doesn't sustain by accepting the reply from the party. That is the reason for a quasi-judicial authority, when he is passing an order, it should always be a reasonable order. So there are certain conditions. What is a reasonable order means? Like he should give audience to the party before the matter is finally decided. A proper opportunity to present his case should be there, and he should hear the matter, and he should record the reasons and why he is coming to such a conclusion that he needs to present it in his speaking order in a very elaborate fashion, by countering the arguments put up by the appellant before them, that why that they are taking a particular legal position and arriving at a decision has to be reasoned. So always a quasi-judicial order has to be a reasoned order. You may say that, see, is it that only the quasi-judicial authorities are bound by the law that they need to pass a reasonable order, whereas the court need not? But in most of the matters, the court need not reason out the orders, that they can pronounce an order which has to be agreed on by all the parties sub judice to them. But whereas in a quasi-judicial order, if the quasi-judicial order is not a reasoned order, certainly that is going to be the primary ground on which an appeal can be filed. So the tribunals are also a quasi-judicial institution set up for the fast, inexpensive, and decentralized adjudication of disputes in various dispute matters such as administrative disputes and tax disputes. So there are administrative tribunals and there are tax tribunals. So the tax tribunals exist in income tax and also in indirect taxes. So there are administrative tribunals which take care of the personal matters. So the tribunals are in both the areas. They function both for administrative and for tax disputes. These are also quasi-judicial institutions. Why do we call them quasi-judicial? Because the tribunal is always a mix of judicial authorities as well as the technical authorities. Who are the technical authorities? They are the subject matter experts drawn from those particular formations. Like, for example, in an income tax tribunal, the bench is constituted by an income tax officer as well as a officer of the court, a judge. So it is a combination of both. So why it is so? That is because that the technical officer will be conversant with the functioning of the department, how the law has to be interpreted, what exactly the field formations understanding on a particular issue. So he can bring the perspective from the departmental side. The judicial officer certainly is going to interpret the constitution and the relevant act and the provisions thereon. Hence, a combination of it is going to give justice expeditiously, and moreover, that you need not spend so much of money as it normally happens when there is any legal proceeding in a court of law. So these are inexpensive and it is a decentralized education. Hence, only for the that particular area focused matters only they will be hearing. Hence, it is going to be a faster dispute resolution mechanism. So that is the reason the tribunals were introduced. The original constitution did not contain provisions with respect to the tribunals, but the 42nd Amendment Act of 1976 added a new part into the constitution, which contains only two articles: 323A dealing with administrative tribunals, Article 323B dealing with the tribunals for other matters. The tribunals and courts both deal with the disputes between the parties which affect the rights of the subjects, but there exists some difference between the two, which are as under: for a tribunal, part of the traditional judicial system, but court is part of the traditional judicial system, whereas a tribunal, it is a quasi-judicial body. A civil courts have judicial power to try all suits of a civil nature unless the cognizance is expressly or impliedly barred. But tribunals have the power to try cases of special matter which are conferred on them by the statutes. So, an income tax tribunal can hear only the income tax matters. A GST tribunal can hear only the GST matters. A administrative tribunal can hear only the administrative matters of the particular departments that they will mention. Similarly, the courts, the judiciary is independent of the executive, but the tribunals, administrative tribunal, is entirely in the hands of the executive. So the quasi-judicial authority creates a tribunal is in the hands of the executive, but judiciary is independent of the executive. So the court is bound by all the rules of evidence and the procedure, but the tribunal is bound by the principles of natural justice. So P&J is a very important thing. This is where that you hear at adi altem partem, all these kind of Latin maxims, which say that you have to adhere to the principles of natural justice. Opportunity should be given to both the parties to present their case, and based on their submissions, the court has to reason out that which submissions are having a merit, which submission is not having a merit, and what are the reasons that it is being discarded for not having merits and all has to be explained in the order. So it has to be a reasoned order. Hence, being a quasi-judicial authority, even the tribunal's orders are should be a reasoned orders following the principles of natural justice. So that is what is tribunal, and what is the GST tribunal that we will see. The next slide, please. Pawan, next slide, please. Yeah. In the 53rd GST Council meeting held on 22nd June 2024 in New Delhi, the Council recommended the fixing of monetary limits for filing appeals under the GST. So, for the GSTAT, if the dispute is about 20 lakhs, then only the matter can be heard by a tribunal. Any matters below 20 lakhs, the tribunals cannot entertain the appeal. High courts, it is 1 crore. Supreme Court, it is 2 crores. The GST Council also recommended reducing the amount of pre-deposit for filing appeals under the GST. So accordingly, the maximum amount for filing appeals with the appellate authority has been reduced from 25 crores each of CGST, SGST to 20 crores each of CGST and SGST. And the amount of pre-deposit for filing appeals with the appellate tribunal has been reduced from 20% with a maximum amount of 50 crores each of CGST, SGST to 10% with a maximum amount of 20 crores each for CGST and SGST. So in order to clarify the matters, at the first level, when you receive an order against which you are going in for an appeal with the first appellate authority, 7.5% of the disputed amount is what is to be pre-deposited. But at the second level, when you are going in for a second level appeal, then the balance of 2.5% is what requires to be redeposited. But this 10% has got a maximum cap of 20 crores in CGST and 20 crores in SGST. So total money paid is going to be not exceeding 40 crores in a dispute. So much of money has to be deposited, and then the appeal has to be filed. These are some of the important amendments that were made. Next slide, please. Yeah, GST Appellate Tribunal composition. Before going into the details of it, that let me tell you some interesting things. Why at all the tribunal is taking so much of a time, everybody may think. But the erstwhile Central Excise Act and all, if you see that after the enactment of those acts, Central Excise and Salt Act is 1944, even before independence. But the Customs Act is 1961. But the SEGAT, the earlier form of SESTAT, was convened somewhere in 1978 or so. So it took so many years for the government to conceive the idea that there should be a tribunal for faster settlement of the disputes. So compared to that kind of a legacy in the GST, after the introduction of the GST from 1st of July 2017, now in 2025, that is, after 8 years, we are now going to see the tribunal's constitution. So, the tribunal under GST has been formed with much more with faster pace when compared to the erstwhile laws. So everybody is saying that why the tribunal is getting delayed. But if they go into the history of the indirect taxes of the past, for the central excise or the service tax or the customs, the tribunal was formed after decades of the law being enforced. But in the GST, just within 8 years itself, the GST tribunal is going to take shape. I do not know when it is, but at least now it is 8 years that, but certainly that we are going to see the light of the day. So this tribunal formation itself was taken for a ride by filing of several appeals in high courts as well as in the Supreme Court. And Madras bench has fought for the rights of the advocates as well as for setting the tribunals in the right frame as per the existing understandings. And they won at several places. Ultimately, the formation of the tribunals now has taken the final shape. Of course, now the GST Appellate Tribunal is a composition which includes a national bench situated in Delhi and constituting the president, a judicial member, and a technical member, one from the state and one from the center. Further, there are 31 state benches consisting of two judicial members, a technical member and a center, and a technical member from the state. So, what is this? Every tribunal has to be having at least 4 members. 2 are from the judiciary, and one member is from the CGST, another member is from the SGST. So, there will be 4 people in a tribunal. So, such 31 state benches will be there. And in addition to that, there will be a national tribunal, which is going to be national bench, which is going to be situated in Delhi, for which the president is going to be the judicial member. And in addition to him, there will be another judicial member, and then there will be a CGST member, and then there will be a SGST member. That's how the tribunal's formation is going to be. The tribunal is not bound by the Code of Civil Procedure 1908. Of course, the CPC has undergone a change very recently in 2023. The new law has replaced it, but follows the principles of natural justice and has the authority to regulate its own procedure. The tribunal possesses powers similar to the civil court under the CPC for matters such as summoning individuals, demanding document production, receiving evidence and affidavits. The tribunal can requisition public records, issue commissions for witness examination, and dismiss or decide representations for default. Orders issued by the tribunal can be enforced as if they were court decrees, with the tribunal having the authority to seek execution within the local jurisdiction. All proceedings before the tribunal are considered judicial proceedings, and the tribunal is deemed a civil court for specific legal purposes, aligning with sections 193, 228, and 196 of relevant legal codes. So these are the important attributes of a tribunal. So this GST tribunal is no different. It follows all these rules. Next slide, please.
Sir, we'll launch a poll, sir.
Yeah.
Audience, I will be launching a quick poll related to the topic that we have just discussed. The poll is on your screens. Who is the first president of GSTAT? Justice Sanjay Kumar Mishra, Justice Deepak Mishra, Justice Ranjan Gogoi, Justice S.A. Bobde. Please type your answers in the poll box, audience. Also, if you have any questions or queries related to the topic, you can type in the Q&A box or the chat. If you want to have any queries, you can type in the chat box. We'll be having a dedicated Q&A session at the end of the webinar. Also, after the webinar, I'll be sending you a post-webinar mailer, including the recording of the webinar, the presentation deck, and the survey form for your topic selection. Please ask your questions in the Q&A box or the chat box, guys. The poll will be closing in under 5 seconds. Thank you guys for participating in the poll. Over to you, sir. Sir? Sir, are you all in?
Oh, sorry, I muted. So I'm repeating the answer to that question. Most of the audience have got it correct. It is Sanjay Kumar Mishra. He is the Jharkhand Chief Justice, and he was appointed as the President of GSTAT. And he took oath in the year 2022. And then he is functioning as the 2024. Sanjay Kumar Mishra is appointed as the first President of GSTAT, and he took oath. And now the GSTAT has to start its functioning. So now what are the issues that we have for the functioning of the GST? Appointment of members. See here what is happening is that all these persons, so that now we have got a CGST member, SGST member, and then judicial members. So the judicial members are to be appointed by the central government. All the CGST members are to be drawn from the CBIC, Central Board of Indirect Taxes and Customs. Then the SGST members are going to be the persons who are there in the SGST department of the respective states. So every state has to make a search committee. There is a set procedure how a member has to be selected. So they have to call for the willingness of the persons who are working, and then they have to scrutinize their applications, and then they have to shortlist the candidates, and then they have to do the background verification of them, and then they have to get the NOC from the department to relieve him, and then he should be given the appointment as member of the GSTAT. So this procedure has to be followed for each and every member who is going to be selected from the SGST or the CGST or from the judiciary also. So it is a mammoth exercise. You may think that there are only 31 benches, state benches, but each state has to do this exercise and complete it in the given time. And after that, in some states, because of the number of cases that may come, that they have allotted more than one bench. So in all such cases, they have to increase the number of members also, and then they have to provide the infrastructure to all these members. And then you know it, a government officer has to function means he needs to have an office, he needs to have his subordinates, he needs to have a vehicles and other things and all. So all these are to be provided by the respective states. So it is taking its own time. And then the government in its efforts to digitize things and not to deal with the paper. So they said that all these filings for the GSTAT are going to be online. And to the extent possible that they have amended many laws. Now the original hearing of the show cause notices is happening online only in most of the cases. only when it is mandated that either the adjudicating authority or the arguing counsel is specifically desires that it should be a physical submission, then only that they are entertaining. So online is by default, and physically appearing before the authority for personal hearing is by choice. So that's how it's happening. But as far as tribunals are concerned, that they want to digitize the whole process, hence they said it is going to be online filing. So there are doubts in the minds of the people that the website address has been given, but whenever we click that website, it is not functioning. That is because that the minute it starts functioning, that people try to file their appeals. So, but the infrastructure is not in place. The adjudicating members were not yet appointed in some states. Hence, they have not made it operational. That is the reason the GST Tribunal website, that you may be seeing it, but it will not function till the time it has been announced that the tribunals, all the members are in place, and the tribunal is going to start functioning from an appointed date. So the notifying the start date is very important. So that one has to wait. So now people have doubts that when their matters have passed the original adjudicating authority, the first level of adjudicating authority, or in some cases the second level, but however, that the matter now has come wherein that they have to file an appeal with the tribunal only if it is in existence. But in the absence of a tribunal, what requires to be done? This is a bigger question for many people. So, because the tribunal is not yet constituted or not yet functional, the government has come out with a clarification that whatever is the pre-deposit that requires to be paid for the matter to be heard, if you have already paid the pre-deposit, the minute you pay the pre-deposit, it is automatic understanding that the stay applies. So your case has been stayed. So there will be no recovery proceedings in all such cases. Hence, that the mere filing of the appeal with the tribunal is the only formality that has remained. Hence, the department is saying that you can file a letter with the department saying that you intend to file your appeal with the tribunal, which has not been in existence. However, whatever is the pre-deposit that requires to be paid in order to get the automated stay that you have already paid, and you enclose the payment proof, and then you just file this letter, that is good enough. So as and when the tribunal gets constituted, till that point of a time, there will be no recovery proceedings against the demand that was made. Hence, the people can wait till the tribunal comes into the existence to file their formal appeal, and the matter will be heard and the decision is going to be given. So such a kind of a facility has been given. So Maharashtra is the first state to issue instructions on these lines. Later, some other states have taken the cue, and ultimately from the CBIC also, such a clarification has come in the form of a circular. So one can refer to that. So any matters which are to be appealed with the tribunal, that you can make the pre-deposit and then submit a simple declaration letter with the department saying that you are waiting for the tribunal to get constituted, but the pre-deposit has been made. Hence, your matter is already stayed till the constitution of the tribunal, and you file the appeal and submit the proof of that appeal and all that. Till that time, there will be no recoveries. So that's how the issue has been addressed. However, despite of these instructions, if somebody is facing any kind of a recovery proceedings and all, then that has to be dealt with in a separate manner. So, because that should not be ideally done, but if some authorities are resorting to such a kind of a thing, then it has to be dealt in a separate manner. But the instructions are very clear to the field formations as well as for the SSCs also, that there should not be any coercive measures to be undertaken. The second aspect I just wanted to touch upon is many people are of the impression that we do not know when the tribunal is going to form. Till that point of time, my board of directors are not going to leave me. I, being the tax head, I'm responsible even to resolve this issue. Hence, why not that I go to the High Court? See, going to the High Court or the Supreme Court in the form of a writ is seeking the extraordinary jurisdiction of those forums. So the High Courts or the Supreme Courts are going to entertain your writ only and only when the regular mechanism failed in performing its duties, or the there are serious demands on you for which that you can't wait for the tribunal to get constituted, a matter be heard, and then ultimately get resolved. So the special circumstances in which they can invoke their extraordinary jurisdiction is something that has to be impressed on at the time of admission hearing. So unless you succeed in that admission hearing, your writ is not going to be entertained by the courts. So the courts will say that when you have got the normal channels of your appeal mechanism, as I told, the original level, first level, the second level, and then the tribunal, and then only to the High Court, if need be, or the Supreme Court. So why you are not following that the normal mechanism that has been given, that going by the hierarchy of the appellate authorities, and by skipping one authority, why are you knocking on our doors? That too to invoke the extraordinary jurisdiction of those courts. So unless you justify that point, that simply that since you have got money, if you want to go and file a writ, it's not going to happen. And in most of the cases, the biggest other problem that we are facing is some of the courts are having very active tax benches. So they entertain your writ and immediately pass the orders also, and it becomes a sensational sometimes, and then the matters are traveling to the next forums like that. But in some of these states, we could see that the tax benches are not getting constituted on a periodical basis, and many matters are kept pending. So because of that reason, that if you are, unfortunately, if you are staying in such states, then what is happening is all these writs that you file will be there in the filed state only, that the matters are not moving. Hence, you will not get any kind of a justice. The only thing is that you can go to the department and say the matter has been appealed, and then the matter is pending with the court. Hence, that there should not be any kind of a recovery. But unless there is a stay, then the field formations may not stop their recovery proceedings. So that is the reason you can always cite the CBIC circular, which says that once you make the pre-deposit and file a simple letter saying that you are intend to file a appeal with the tribunal, then the recovery proceedings should not be initiated against you, that the recovery officers will be behind you. So that we need to keep it in mind and act very judiciously. But knocking the doors of the High Court or the Supreme Court in the form of a writ is not a default way, because the tribunal is not yet constituted, because it is very unlikely that your matter may not fit into the special circumstances in which the courts will be exercising their extraordinary jurisdiction in order to entertain your writs. So keep that in mind while advising your respective managements. Otherwise, what happens is that you do an exercise which will become futile. And if the court ultimately, after taking its own time, decides that you should have gone through the normal channels, then whatever time that you have spent in this frivolous litigation is going to be lost. And every day in the litigation proceedings is very important, because the interest burden will be mounting on you. And under the GST law, the interest, you know it, it is 18% in all normal course. But if it is a misuse of your ITC, it is going to be 24%. I don't think that any business is making so much margins in order to meet the interest liability. Hence, your decision to your management should be on reasoned grounds. So think twice before taking a decision to go in before a high court by bypassing the tribunals, though they were not constituted, but that is the way in which one needs to think. Next slide, please.
Sir, we'll conduct a small poll.
Yeah, please.
Guys, I have pasted a link for a poll that is happening in our LinkedIn. You can just click on the link and you will be redirected to the LinkedIn. You can participate in the poll. Please click the link in the chat box so that you will be redirected to the LinkedIn poll that is happening in our page. I'll be reading the poll question. Under GST, litigation can arise due to validation issues, misinterpretation of laws, violation of tax procedures, all of the above. Please click the link in the chat box so that you will be directed to the poll in our LinkedIn page. You can see good number of participation in the LinkedIn poll, guys. The remaining people can click on the link and post the answer.
For your benefit, the answer is there already. Hence, you have to just select that right alphabet.
Yes. Also, guys, we'll be posting regular GST updates and the platform tag automation about GST, everything in our LinkedIn page. So you can follow our LinkedIn page named WebSol so that we will produce you the daily content about GST, accounting, the software and the trends about all the GST and accounting. Please follow us on LinkedIn for more updates.
It
Thank
has
you,
got
guys.
the articles and blogs also on the GST.
Yes, sir. Also, we produce a lot of blogs and articles related to GST as well. So please follow us on the LinkedIn, guys.
And on the same page, I think that you have got all the webinars that we have conducted. Those links are also available. Hence, anybody who wants to see the previous webinars for on any particular topic, that they can refer to that.
Yes, since most of the audience were asking about IST related webinars, we have also posted those links and the highlights of the webinars in the LinkedIn page as well. Thank you, guys. Over to you, sir.
Yeah. So the way forward that we have is there is no indication about the start date of functioning of the tribunal in the recent budget presented on 1st of February 2025. Lot of changes in the hierarchy of the relevant authorities have happened, that you know it, that in quick succession that we have got we are now going to have the third revenue secretary, and the states have to yet to appoint their SGST members, and center has to appoint their CGST members also. And you know it, once it is a May, then it is a season for transfers and all that, and then there will be promotions. Hence, we need to see if somebody is appointed a member, and if he suddenly gets a promotion, then he will relinquish this appointment, then he will go for the regular promotion and all that. So such kind of dynamics are also there in the play, and provision of infrastructure by all the states is not yet over, and creation of a functional website for the online filing of the appeals is still pending. So with these many problems that the tribunal functioning is not yet happening, hence we need to wait and watch when it is going to be the day when this online filing can happen and the tribunal really starts functioning and starts dishing out the needed justice for us. I think with this, I am coming to the conclusion of my presentation. So if you got any kind of a questions, then certainly that I will take it. But already there are two queries in which are posted in the Q&A, which I am going through. How much is the pre-deposit for appeal at the commissioner and tribunal for filing the appeal? See, this question cannot be answered directly because I told you that at the original level, you need not pay anything. But when you go to the first appellate authority, it is 7.5%, and then subsequently with the second appellate authority, 2.5%. So in such a scenario, you got to see where exactly your original show cause notice has been dealt with. If it is with the commissioner, then with the tribunal that you have to pay 10%. But if it is at a lower level at the AC or DC, then the first appellate authority will be the JC, and with him that you will file 7.5, and the second appellate authority will be the Commissioner Appeals. At that point of a time, maybe the balance 2.5%, or at the time of filing with the tribunal, the balance has to be paid. So depending on the authority who has passed the earlier order, the pre-deposit amount 7.5 and 2.5 is in two tranches that you have to make it. Then what are the monetary limits should consider? The basic demand or total demand, including the interest and penalty. It is never with interest and penalty, because interest is something which is dynamic. Penalty, of course, is fixed, but they go by the tax amount only. Hence, for monetary authorities and all, it is the tax amount which is involved. That is to be seen. And audit authorities are adjudicating the matters. Is it valid? See, that is what I told, that when it is a quasi-judicial authority, then he is the person who is going to ask you the question, and he is the person who is going to evaluate the answer given by you and then confirm the demand. So quasi-judicial authorities function in both the ways. Hence, they can. But normally, audit or investigating authorities, after the ruckus which has happened at the Supreme Court in several of the matters where DRI has issued the notice and tried to adjudicate the matters and all, then which has been questioned. So that matter is now pending. So in most of the places, audit or the investigating authorities, though they may issue the notice, but they are not adjudicating the matters. So certainly you can cite that Supreme Court decision, which is currently pending the final answer. Hence, based on that, maybe that you can try. But quasi-judicial authorities slightly have got this kind of a dual power, where they can question, and on their question, they can also demand after going through your answers. Under what circumstances the tribunal can be bypassed and matter can be taken up to the court? I think elaborately I have dealt with you. There should exist extraordinary circumstances that the normal channels were not made available to you, and because of that reason that you were subjected to severe financial hardship, or that even if I go through that, you may not get the proper justice. Hence, you are asking for the courts to exercise their extraordinary jurisdiction. So unless you were able to convince the court to entertain the writ, that you will not be able to bypass the tribunals. But when appeal filed before the first appellate authority through GST portal, the pre-deposit calculated is at the rate of 10%. Sir, it is not. Why it is happening 10%, I do not know. You have to just check. It is 7.5 only, no? It is not 10%. See, what is that? This 10% calculation, whether it is a GST interest penalty, normally interest and penalties will not come. But if it is a demand only for, see, if it is a demand for both tax and penalty, interest is never there in the calculation. If it is a demand for both tax and penalty, then 10% of the tax amount. But if it is a pure demand only for the penalty, then it is 10 percentage of penalty. That's how it is. What is the solution if any appeal is rejected by appellate authority? I've already told you, when a case has been rejected by the appellate authority, you have to go to the next authority. If the next authority happens to be tribunal, then you file a letter with the department saying that you intend to file an appeal with the tribunal which has not yet been constituted, but whatever is the pre-deposit that requires to be paid, that you have already paid, and give the evidence of the such payment, and then there should not be any recovery proceedings against that. So you have to declare this in the form of a letter. Department is asking to pre-deposit 30% to stay the dispute to be filed in the tribunal. So, no, sir, there is no authority for them. They cannot simply put their own numbers in the letter issued to you. So you can ask them under which rule. Then they may be able to tell you. They will not be able to tell you. Then they will correct themselves. If an ADT 2 is issued and blank DRC 07 is attached to the audit report, can it be argued in the appeal that the RTP is not liable to make any payment. Perfectly, sir. But the thing is that you need to have an evidence to that it is a blank DRC 07. So it should be evident on the face of the GST portal, because nowadays all the orders are getting posted. Hence, you have to have that evidence.
So I think we have some questions in chat box.
Yeah,
Meanwhile,
I am going through them. We have a refund pending for the exports. We are a software firm. So you can be any, sir. But 2017-18, if the refund is pending and you are simply idling, then it is a wrong. So you got to find out why exactly the refund is pending, and they have to issue some orders. At least that status that you should ascertain in writing from them in order to proceed further. That is the suggestion that I'll give, that you have to write to them that why the refund has not yet been granted and what are the reasons for holding it back. In writing, that you have to get an answer from them. So depending on that, you can go for the higher authorities. A minimum 10% pre-deposit, minimum 10% pre-disputed tax needs to be paid as a deposit before filing an appeal. Once the CCC, whatever is the minimum that is prescribed under the law, that you have to pay it, there is no doubt, then only it gets admitted, but it will not flag it as a disputed amount as non-recoverable. See, it is the disputed amount, non-recoverable means already the amount has been deposited. Hence, a further recovery of this amount need not be done because it is already there with the government. But you need not read it that it is non-recoverable means that you cannot get it back. Once you win the battle and ultimately the matter has been decided in your favor, definitely you will get back this pre-deposited amount also. There is no doubt about it. We have filed a refund, no orders. We have written many times. Then you have to escalate it to the next level, sir. It is not sufficient that you have written many times, no replies to the date. You have to escalate it. If you have written to the AC, then you escalate it to the commissioner. Moreover, all these refund related issues, that the updates are available in the GSTN portal also. If the portal is not showing any kind of an updates, definitely you have got a very valid ground to go in for an appeal against it. So you escalate the matter immediately to his administrative boss, the next level of the authority with whom that you have filed it.
sir, I think Suresh is having some
Yeah,
questions,
you can ask.
clarification.
We have involved the IT secretary. They neither cancelled the refund request nor passed the. We are planning to go to High Court. Jolly well, sir. If you collect all these evidences that there is no reply and all your letters have gone unanswered by them, and then whatever is the correspondence that you have made to the IT secretary and the actions taken thereon, and the GST portal being blank on your refund status, all these you can furnish it as an evidence, and then certainly the court will entertain your writ. It is a good case.
Sir, can I add if you can hear me?
Yeah, please.
Sir, they are not even accepting letters submitted directly. Now, after many attempts, initially they said pandemic, many other things. Finally, when we go personally try to deliver the letter, they are not accepting, or they accept it and no action will be taken. Now we have sent
which state, sir?
To prove it to be presented to the High Court.
No, which state you have faced this problem?
Interestingly, Kerala, sir.
Oh God, Kerala.
Very notorious for this.
I think in one of the last meetings also you have raised this question.
Yes, I have raised this question and you advised me to go to the High Court. I tried all the other possible routes, but still we are back to the same routes.
No, but that's the only way you have, because if all your written communication is unanswered and the IT secretary is also not able to do anything and all, the final result is going to be the High Court only by showing all these evidences that your writ is certainly going to be entertained.
Yes, sir. That's what I am planning to do. I was taking your advice on this once again.
Yeah.
Thank you.
Then there is another question. Since the tribunal formed state-wise, is there any chance it may be influenced by the state government? Then the decision of the tribunals may be. See, ma'am, the thing is that though the tribunal is formed state-wise, as I told you, that there are 4 members in the tribunal, right? There are two judicial members one state CGST and one SGST. So when a division bench is constituted, it is constituted with one judicial member and a CGST, or one judicial member and a SGST. So the state government cannot influence the decisions. Your apprehension is right, because the way AAR decisions are going haywire nowadays, that there is a possibility that you may be thinking, but the possibility is very less, because if it is a matter to be dealt by a single member, then yes, the state government, whatever dictates, because that he is a member of the state, if he still have got that kind of an allegiance, then he may take a biased view. But normally, the persons who are sitting on the tribunal benches and all will be non-partisan. And so I don't think that such kind of a thing can happen, that the state diktat is still implemented by them. So remote possibility, but I am not saying that it's completely ruled out, but the chances are very less, because it applies only for a single member. But when it is a division bench, definitely the judicial member will be there, and he'll also have a 50% say. So the chances are less. That is the only thing that I can say.
Sir, Manoj, sir.
Yes,
Yeah,
Manas,
yeah,
you can ask your question.
Yeah. So that my point is that regarding the time of the filing first appeal, what we are doing the 10% on the pre-deposit on the disputed demand.
right.
So is it? I mean, this is the first appeal. When tribunal is not yet constituted, still the action is not yet started. So when will they go to the filing the tribunal? What percentage we can pay?
No, sir. You tell me that who is the authority who had issued the show cause notice to you?
That is only JC.
So a joint commissioner's order. So JC is going to decide the matter, or he made this answerable to the commissioner.
All right.
See, while issuing the show cause notice, did the JC say that you are answerable to the joint commissioner, or he said that you are answerable to the commissioner? What did he say? The last paragraph of the show cause notice.
That is answerable of the. There is not a mention anything, because I am
No,
talking
sir.
this is
He will mention to
because the
whom you have
last,
to reply to the show cause notice. He will mention.
because this is a which we had got the order, something in details, so that is there mention is that JC is a pass the order.
No,
But
no.
there is
You
a
are
mention
getting
that
confused.
if you want the file the appeal, so they can go to the file for the within 3 months.
No, you are getting confused. What I have asked you is, who has issued the show cause notice? You are talking about the adjudication order. If the adjudication order has been issued by the joint commissioner, is it the SGST authority or CGST authority?
That is a CGST authority.
CGST.
Right, sir.
Central.
Yes, yes.
Yeah. If it is a central, then the next appellate authority happens to be the commissioner appeals.
Right, sir.
So you have to go to the commissioner appeals, no?
Okay.
So by paying 10% of the pre-deposit, what you have to go to, you have to go to the commissioner appeals. Once the commissioner appeals also decides, and if it happens to be against you, then that time that you have to go to the tribunal.
Okay.
So you still have one more level before reaching the tribunal, right?
For the time of the filing the tribunal, because the tribunal is not yet act now.
Sir,
So
you have to file it with commissioner appeals first.
Right.
So after the commissioner appeals order only, you can think of tribunal.
Okay.
So why are you now coming to the thing that tribunal? Because tribunal may get constituted by the time you get an order, right?
Right, sir.
Because
right.
any day that it may come in existence, hence that we need to wait. That's it.
Okay. Okay,
Yeah.
sir. Thank you.
Then there is one question. Can we avail the amnesty scheme for an order under Section 74? Clearly, I think in the FAQs that they have told that this amnesty is not applicable for Section 74 demands, right? So I don't think that it is possible. And Manas wanted to ask some question.
He's the Manas, the one
Yeah.
who talked. No?
Okay. Just right. So I think I have answered all the questions. If any other topics also, if you got any questions that you can ask. But from 1st of April, that you are going to have another complaints burden on you. As I have explained in my last webinar also, that the ISD, those who are having multiple units in multiple states, then they should go for the ISD registration, and then they have to get all their input invoices into that ISD, and then they have to distribute it. And as far as reverse charge mechanism is concerned, it is going to be a bit more complex, that they have to take it in the regular registration, pay the reverse charge, and then transfer that to the ISD, and from the ISD you have to distribute it. And wherever that you feel that some credit is not eligible in your hands, but you cannot simply take a call that I will not take that credit. You have to take the credit, distribute it, and then at respective locations that it has to be reversed. So all these points are there, which are slightly adding to your compliance burden. Hence, that is the time when you have to seriously think of automating your processes by taking the help of any ASPs and GSPs also. So think twice, but April 1st is around the corner for you. And from that time onwards, for multi-registration units, definitely another headache is there in the office. And tomorrow happens to be Holi. So I wish all of you a very happy Holi. On that note, I don't have anything from my end to present. If any more questions also, I'll entertain. Otherwise, goodbye for now.
Thank you, sir. Thank you for the very interactive webinar. Also, guys, I will be sending you a post-webinar mailer along with the recording of the webinar and the presentation deck and the form for your topics. Please follow us on LinkedIn and all other social media platforms for the updates. Thank you, guys. I think, sir, we'll close up with this question. Okay, this is thanks. Thank you, sir. Thank you, audience.